we are addressing the question today of whether or not a person can have to pay the attorney's fees for their spouse in a divorce case when there is not enough community property to pay those attorney's fees, meaning all of the money in this case is the separate property of husband, and wife was awarded attorney's fees. So his separate property in this 2022 case out of Dallas in Texas, his separate property would be paying her legal fees in the divorce. Now, it can be an enormous factor in the final outcome of a case who is paying the attorney's fees. And in this case, the husband appealed, saying that wife's award of attorney's fees, that the attorney fee award to mother was improper. So the father in this case is saying that the mother should not have won the attorney's fees in her favor in the decree of divorce. So here are the background facts. The mother and the father were married in 2016, and they had a child, A.P.N, who was born the following year. Prior to the marriage, the mother and the father signed a premarital agreement, a prenuptial agreement, saying that their separate property and any property acquired during the marriage would remain separate. So that's basically the classic prenup, is that the parties are keeping their own money. Then in March of 2018, mother filed for divorce. He filed a counter petition for divorce, as is normal and common. And the mother's petition, her divorce lawsuit, sought attorney's fees so that they could have an equitable division of the estate. And she asked for attorney's fees regarding services rendered in connection with the conservatorship questions in the divorce. They went to a bench trial, which is a trial that doesn't go to a group of a jury. It goes to the judge, which is the most common type of final trial for divorces in Texas. And that trial was held in July of 2019. And the trial court ordered the outcome, which is what happens at the end of a trial. And basically in that, the parties' rights and obligations with respect to A.P.N, so the parental rights were ordered, and the father was ordered to pay $14,900 in attorney's fees. And $10,000 of those fees were to be paid directly to mother's counsel. So the father was ordered to pay the mother's attorney's fees. Now, the mom, in this case, in this appeal, which is what we're reading, this is a primary source of law. This is an appeal case in Texas 2022. Even though this is in Dallas, it applies to anybody. This law applies to anybody in the state of Texas. So the father filed an appeal saying, I should not legally have to pay those attorney's fees. And basically, this is the court analyzing the law and assessing what the father is saying. Is the father required to pay the legal fees for the mother in this divorce case in light of their prenuptial agreements? So the father is saying that the trial court committed a mistake by awarding the attorney's fees to the mother. And he's arguing that the prenup that they had provided for separate property, and that the husband and wife had no community property. So there wasn't any community property for the trial court to divide. So the source of funds for the attorney's fees, what father is arguing, that source of funds didn't even exist. So how could they order him to pay attorney's fees when all he had was separate property money and all she had was separate property money? So they're talking about a different case and how that court handled that. And in this different case that happened historically, that is what was found, is that when there's community property, attorney's fees can be awarded, but when there isn't, attorney's fees cannot be awarded. That's what was historically the case. But then look at what the Court of Appeals does here. They say in 2013, the Texas legislature amended this part of the Texas Family Code, section 6.708 of the Family Code, and it legislated that in a suit for dissolution of marriage, the court can award reasonable attorney's fees and expenses. The court can order the fees and expenses and interest to be paid directly to the attorney, who can enforce the order in the attorney's own name by any means available. So that was the Texas Family Code. Now, basically, what they wrote here is that as the first Court of Appeals recently noted in addressing the same argument, so they're saying the Court of Appeals already addressed this argument that the father is making. The Court of Appeals said Section 6.708C, the legislated law, contains no requirement that in setting the amount of attorney's fees award in a divorce proceeding, that the trial court must take into account the value of community estate and may not award attorney's fees in an amount that exceeds the value of the community estate. That's what the Court of Appeals already said, is that this law that was written right here doesn't say that the funds have to come from the community estate. If that had been the intent of the legislature, then they should have written that. But because that wasn't explicitly written, we are allowed to award attorney's fees from separate property. So a trial court may award attorney's fees even if there is no community estate to divide. And they upheld the order that father pay attorney's fees. In a divorce case, if it's separate property, if it's community property, the court has the power to order reasonable attorney's fees be paid by either side, to either side. It is the trial court's in its sound and good discretion to do so. If this was of use to you in any way, shape, or form, giving us a like, giving this video a like helps the video rank better. And it's always great to have the ability to reach out to people and talk about primary sources of family law from partisfriends.com. Thank you for stopping by, and we hope you have a great day.